Hello, everyone, and thank you for joining us this afternoon for a new SARE webinar on how artificial intelligence can protect consumers. We're just discovering the significant impact AI plays in our daily lives. When we book a hotel room or when we buy a plane ticket, the price that we're going to pay is going to be determined by artificial intelligence. When we are preparing our shopping list with the help of a voice assistant, artificial intelligence is present. And there could be many examples like that I could give you, and which all illustrate the expanding, the increasing role that artificial intelligence plays in a number of businesses and consumers' choices. AI brings benefits, but it also raises significant challenges, and challenges, for instance, in the areas of consumer protection. When I think of challenges and risks, I could refer to transparency or perhaps lack of transparency in algorithms, or cognitive biases and discrimination. In addition, when it powers killer robots or facial recognition devices, or is also leading to invasion of our privacy, it's clear that AI is also related to the issue of our fundamental rights and our democratic values. To discuss all this, I've taken you this afternoon to a very special place. And this is the Artificial Intelligence Experience Center of the Vrije Universiteit Brussels, the VUB. And this is a great innovation hub in the heart of Brussels, in the heart of Europe. And it provides, I think, an impressive examples of the myriad of artificial intelligence experiences and developments which are going on in our continent, in our union. And the interest of this place is also that I think it illustrates well the European human-centric approach that aims at putting the welfare of users and citizens as a key feature of new AI tools. Now, later in the program, we'll have a presentation of a very, very innovative tool, AI-powered tool, which help consumer to screen their online contracts and check whether those contracts are in conformity with EU law. And this will be followed with a discussion between policymakers, civil society, and academic experts. But before that, I'm very pleased to welcome, shall I say, a seasoned Belgian and European politician who has a key responsibility for the issues we are going to be talking about this afternoon. The reason for that is that he's been mandated by President Ursula von der Leyen from the European Commission, and I quote, to contribute to legislation towards a coordinated approach on the human and ethical implications of artificial intelligence. He's the European Commissioner in charge of justice, the rule of law, and consumer protection. Good afternoon, Didier Reynders, and thank you for having accepted our invitation to discuss all those very complicated issues that we are going to be dealing with this afternoon. I've talked in the introduction about the benefits. I've talked about some of the risks and the challenges that AI is raising. And it's not surprising, therefore, that we see that that raises issues related about trust. Trust, or perhaps lack of trust, in AI on behalf of citizens, but perhaps also at a time where public governance and governance, the trust in public governance and in governments is dented, some issues about trust in the rules and the laws which are supposed to protect us against the risk of AI. So basically, my first question to you is very simple. What is your strategy? What are you going to do to regain citizens' trust?
Well, good afternoon first, but the citizen trust, it's at the core of the project for the European Union. And so we need to build trust between member states, we need to build trust between citizens and between different actors in the European Union. And we have published last week the first annual report on the rule of law. And that's the demonstration that we need to pay attention to the core values of the European Union, the values that we are sharing, like democracy, fundamental rights, and the rule of law. And of course, it's possible to do that with an analysis of the different behaviors of the government in different fields, but certainly also about the new technologies. And when we are speaking about AI, it's important that we are sure that it's possible to protect the fundamental rights, to avoid any discrimination in the use of AI. That's the first part of the process, and to be sure that you put the human being at the center of our strategy. So a human-centric approach, of course, for AI. And so it's true that we need to invest a lot in skills, in research, in infrastructure to be able to develop AI at the European level. But we need to do that in such sort of a European way to use AI. And the European way is all the time to pay attention to the fundamental rights and to the protection against all the possible discriminations. And that's the first concern that we have. Of course, we have other concerns about the introduction of AI in different products and services. But the first one is to be sure that we are protecting the fundamental values also in the use of AI.
The Commission has proposed ethical guidelines,
Yeah.
but when it comes to, I would say, concrete programming, application, implementation of ethical guidelines, who should decide what is ethical, what is not ethical? Should it be the European institutions, other institutions? Should it be self-regulation?
Maybe a combination of all those elements, but we need to have some standards. And again, when we are looking to the fundamental rights, we have the Charter of Fundamental Rights at the EU level with some standards inside. We have sort of treaties. And then we have, in the evolution of the different processes, different supervisory authorities in charge to follow that, but also the Court of Justice at the EU level, the European Court of Justice, or the European Court for Human Rights. So we have also case law coming from different Court of Justice to set up a different framework of rules. But more than that, I want to say that it's very important to think about a possible regulation, to ask some requirements to the companies or to the different actors coming with AI. Different examples, maybe the first one. Is it possible to receive a documentation about what is it? You are coming with a new product, with a service, including an AI application. What is it? Do you have a documentation about the content? Like we ask a documentation about food, about all the kind of products, but why not about AI? That's the first element. Second element, is it possible, like we have seen here, to test the application before to put that on the market, before to go to the consumers or to the citizens with a specific application? And then we are afraid about some risks, so we'll pay maybe more attention to the more risky sectors or the more risky applications in healthcare. If you are using AI, like we have seen, to help in a possible operation in your brain, of course, it's more risky than other kind of application. The same in mobility. If you have autonomous cars, of course, it's more risky than other kind of applications. So we are thinking also about what kind of risk, and maybe more than that, the opacity of some applications, including AI, because we don't know exactly what are the algorithms, what are the data used, what are the possible bias or possible discrimination, the use of data. And so it's a set of rules that we need maybe to put into place, and we'll think about that till next year, because we want to come next year with a regulation to say what is the possible documentation given by the producer of some products and services with AI including. What are the possible tests to be sure that you are not going to the citizen, the consumer, without a real certainty that you don't take too many risks? And then what is the possible access to the functioning of AI and the applications, to don't have a black box, to don't have too much opacity? And it's important to define those different requirements before to start maybe the use of some applications.
But you talk about rules, about enacting rules, enacting a legal framework. We know that AI is evolving so rapidly. So you think that you should go towards immediate enactment, or perhaps allow for a period of experimentation. I refer, for instance, to the US, where for cars, there's been some kind of regulatory moratorium. Do you intend to adopt the same approach?
But it's possible to put into place some rules and then to try to organize a process with also the same rules applying to the evolutions that we will have in AI. It's the reason why we have many discussions about the definition of AI. There are many definitions of AI. And I know that we have had some definitions speaking about learning machines or expert systems, but there are other kind of possibility to use data and then to organize an application on the base of the data that you have or store in your system. And when you look forward, you see that we will use more and more industrial data, not only personal data, but we'll use so much data that it's very important to be sure that it's possible also to avoid, I said, different kind of risks, and certainly the risk of a discrimination. To give an example, I don't see that in those applications, but if you try to organize a process to recruit people in a company or in an administration, and you want to do that with AI, with an automatic system, maybe on internet, of course, you will put in your system some data, and you will organize a process on the basis of the different data that you have put in your system. But if you ask to a learning machine to use data from the past about what are the best qualities to exercise a top function in a company or a top function in administration, you will receive maybe different remarks and data about men more than about women, because in the last decades we have had more men than women at work in such a kind of function. So we need to say no. You need to don't use such a kind of data. You need to change the way to think about that, to be sure that you avoid a discrimination, in such a case, a gender discrimination, but maybe discriminations about some minorities in the society, and some risk about the fundamental rights of the individuals. And so if there are some evolutions in the future, like you said, we will continue to apply the same set of rules, maybe with some adaptations and change if it's needed, but the principles will be the same.
Mm-hmm. Let's talk perhaps 1 minute about the global ambitions of the EU in that area. AI is a phenomenon which is developing globally, and it's also developing in countries which don't necessarily have the same approach as us, which are not necessarily interested or focusing about rules and ethics, but perhaps more on experimentation. So when you are considering the development of a European legal framework, how are you going to make sure that the EU leads in providing what we think are the right rules, the appropriate rules, and at the same time being sufficiently innovative and competitive? Isn't there a trade-off there?
No, first of all, we need to have a data strategy, and we have decided to have a data strategy, so to invest in skills, research, infrastructure, to be sure that it's possible to develop in Europe the capacity to be maybe a front runner also in the development of AI, in innovation and in research in that. And it's a part of the business. So we need to invest a lot of money in such a kind of process because we need skills again. So in education, we need to invest with more people involved in the educational process to be able to work with AI and with all the development that we will have in innovation, but in research and in some infrastructure, because we need to store some data in Europe. We need maybe to have a European cloud. We need to do that to prove that it's possible to invest at the European level. But at the same moment, we will do that with our way to organize the process, I said, with a real protection of fundamental values, fundamental rights, to avoid any discriminations. And there are two ways to have an influence outside of Europe about that. First, of course, to try to promote our rules. It's possible to try to convince different partners to do the same or to go in the same direction. If I may, comparison, it's possible with the GDPR about the protection of personal data. Since 2 years now, more than 2 years, we have the GDPR to protect the personal data, but we have seen in different parts of the world an evolution in the same direction, from Brazil to Indonesia and from South Korea to Japan. It's possible to see also in the US that we have some evolution to go in the same direction. So we try to promote our rules, also in international fora like the OECD or maybe the UN and others. And the other way to have an influence is to ask to all the companies and to all the actors operating in Europe to apply the same rules. So if you have a company coming from out of Europe, coming from abroad, and coming with AI in a product or in service, it's possible to ask to have a full respect for the same rules than the European companies established in Europe, because you want to work on the internal market. So there are two ways to try to promote our vision on the use of AI. Of course, it's to try to convince different partners to go in the same direction, but it's also to have a level playing field with all the actors coming to Europe or establishing in Europe their activities.
The Commission has conducted earlier this year a stakeholders consultation on AI. Can you share with us the first results or lessons that you drove?
We are for the moment in an analysis of more than 1,000 response to such a consultation, so it's very important to see that. But there's a real request for many people, first to pay attention to the fundamental values and the fundamental rights. And so the human-centric approach is very well shared by many participants and stakeholders. Then, of course, there is a real desire to invest more in AI and in the new technology. So it's not by coincidence that we have decided to have the Green Deal on one side in the priorities of the Commission, but also the digital transition, because we need to invest more in the digital transition for many different actors. So there's a real request to invest a lot, but to do that in a way that it's possible to protect the values that we are sharing at the EU level. And then, of course, we have different remarks about other kind of issues. And if I may, in my portfolio, when you have said I'm in charge of consumers, but also the justice portfolio, of course, we need to think about the safety of the products and the services for the consumers. Or it's possible to be sure that if you have AI inside the process, inside some applications, you have a real safety for the consumers. But sometimes it's also possible to use AI to give a better safety to the consumers. To be concrete, in the platforms with online sales, it's possible with AI to detect different kind of rogue traders or products, unsafe products detected in one of another member state of the European Union, and to try to share the information. So it's on both sides. We need to be sure that it's possible to have products, safe product coming to Europe or developing in Europe, but also to detect maybe those products through AI. Such a first reflection that we have also. But there are so many requests in the consultation about what kind of liability. Because to give the classical example, if you have a car without a driver, in a case of an accident, there are only one thing that is possible to be sure: the responsibility, the liability is not in the hands of the driver. You don't have a driver. So is it the owner of the car? Is it the producer? Is it maybe the developer of AI used in an autonomous car? It's very important to do that. And why? Not only to protect the users, but also to protect the different companies. Because if you are knowing your risks, it's possible to ensure your risk and to be confronted with the reality that it's possible to have a real cost for such a risk. If you don't know the risk, you don't know also the cost of a possible accident.
Does it mean that we need to consider, you are considering changes to the product liability regime?
It's possible, yes, we are thinking about that, because we will have new elements in the new way to use AI in different products or services. And it will be very important to have the classical liability, but maybe extra contractual liability. It's also very important to think about that and to change the way to organize the process. And again, it's very important, of course, because if something is going wrong, you need to know what is the liability of one of another actor. But for those actors, it's also very important to have an idea about the risk that they have in their activities and their operations. Again, because it's possible to take an insurance to cover that, or to take other initiatives. If you have an idea about your responsibility or your liability in such a process, it's possible to integrate that in your business plan and in your development.
We're coming to a close of this discussion. We are 1 year, or let's say one third through your mandate as commissioner in charge of justice, the rule of law, consumer protection. In the area of AI, when your mandate will end, what will be for you the markers of success, which you will say, this has been my success in this area?
For the Commission first, and the entire Commission, it will be a real development of AI in Europe. to be sure that it's possible to develop AI on our continent, because maybe we have a lot of things to do, I said, in investment, in skills, research, and infrastructure to do that. But the main achievement will be to show that with a human-centric approach, like we have said, so with a real concern about the fundamental values and the fundamental rights of the citizens and the capacity to avoid discriminations, we'll build a real trust between the consumer and the companies, between the citizens and the authorities. And it will be a real success if it's possible to prove not only in Europe, but out of Europe, that it's a real add value to do that. Because if you don't have a real trust between consumers and producers, or between citizens and authorities, how is it possible to think that we will develop the use of AI in the future? And I'm sure that also for US companies, or maybe, I don't know, for Chinese authorities, it will be one day important to think that the question of the trust is very important in the relations with the citizens or with the consumers. And we try to build on it. So at the end of the mandate, of course, for the entire Commission, it will be very important to show that we have developed AI in Europe, but it will be also important that we have convinced maybe many partners that the way to develop AI with a human-centric approach, with a real attention for the fundamental values, is the only one way to build a real trust between the consumers and the companies, and between the citizens and the authorities. Just to give an example, during this pandemic, the COVID-19 pandemic, we have tried to put on the table some guidelines and guidance about the tracing apps. But of course, if you don't have a trust from the citizens in such an app, because you are protecting their rights, you don't have any chance that it will be used. And also, if you have some level of trust in the content of the apps, it's difficult to ask to use. But we have seen with such a kind of example that the trust is fundamental. So again, the success at the end of this mandate will be made to me to see that we have built a real trust between the different actors in Europe, and that we have the capacity to show to the rest of the world that the trust is a real add value due to the protection of the fundamental rights in the way to use AI in different products and services.
Thank you very much, Commissioner. I think it's interesting that we started to talk about trust and we're ending with trust. So clearly, this is going to be the marker of the commissions, of the college, but also of Didier Reynders' action in this endeavor. We will at SER, we will obviously continue to our activities on AI and continue research projects, dissemination activities, with the very clear purpose of feeding and contributing to the policy-making process that the Commissioner has just explained. So now I would like to go over to my colleagues, Alexandre de Streel, who will introduce the new innovative software, Claudette. Thank you.
So, good afternoon, everyone. So we have just seen that the AI is a priority for the European Commission, but it is a priority for many people and for SER, obviously. So we have started at SER a series of reflection on artificial intelligence. We had a seminar on explainability of AI, which is a way to increase the trust that Commissioner Reynders was mentioning. And today we want to discuss and take another angle of artificial intelligence, because very often we mention the risk that AI can bring to consumer, and there are some, and Commissioner Reynders mentioned some of them. But AI is also a big opportunity to protect consumer and increase the enforcement of consumer protection rule that we have today in Europe. And that is what we wanted to explore in this seminar, is how AI can help to protect the consumer better, and how AI can help the enforcement of the existing consumer protection rule. For that, we will have a presentation by Giovanni Sartor, who, with some colleague in Bologna and at the European University Institute in Florence, has developed a very interesting and innovative tool exactly for that, to help the enforcement of consumer protection. And then we will have a debate, and in the SER tradition, among different view, we will have the European Commission, we will have the civil society, and we will have the academics. And I already thanks very much all the speakers for being with us this afternoon. So you can ask some question during the presentation, and you have the link on my back via Slido at SER Digital, and then at the end of the debate, we will take your question. So first, Giovanni, could you present us Claudette? And thank you very much again for being with us.
Thank you very much, Alexander. I am very happy to be able to present the Claudette system to you and to the other people participating in this great event. Let me share my screen and get started. Okay, the Claudette system is a small reality, but for, I think, a great purpose, which is showing how AI can contribute to empower consumers. It is a joint effort involving the outcome of a joint effort involving a team of lawyers and computer scientists from the UI and the European University Institute and the universities of Bologna and Modena. Recently, as we all know, as we also got from the speech of the commissioner, we have a situation in which AI is at the service of business, and it is possibly, and to some extent, also to the detriment of consumers in various cases. And values such as privacy, autonomy, the economic interest on consumer equalities are challenged by certain practices that are taking place, also with the support of AI. We all know of that, but there is also another phase of AI. AI can also unlock consumer empowering technologies. It can be used at the service of consumers and contribute also to some extent to counter those very risks, those very issues to which AI to some extent contributes. There are various ways in which AI can contribute to empower consumers by protecting them against monitoring, supporting the detection of unfair uses of AI, controlling fairness in relations between businesses and consumers. AI can contribute to make consumers and their organizations are a countervailing power that can effectively respond to the challenges that consumers are meeting today, especially on online markets. So there are a number of AI AI software that can contribute to this purpose. So we have spam filters, ad blocking tool, anti-tracking tool, price comparison, and the tools that help to detect and respond to violations of law and ethics. In this is where we tried to contribute, where we contributed to our Claudette project, which started a few years ago, thanks, as I said, to this collaboration between the UI and a computer science department in Italian universities. The purpose of Claudette is to automatically detect unfair clauses and potentially unfair clauses in terms of services and privacy policies. We know what is happening. Consumers usually agree to contracts, but they don't read them. And the consumer organizations have a competence to control, but lack resources. And the same apply also to authorities charged with data protection or consumer protection. In this context, unlawful clauses continue being used, and on the basis of such clauses, consumers often don't exercise their rights, and unlawful practices continue. So how did we start? The idea was to train an AI system so that the system would be able to detect unfair clauses in online contracts. For this purpose, we used a supervised machine learning methodology, which means we had to teach the machine how to recognize unfair clauses. And for this purpose, we have tagged a number of online contracts, now about 100 of them, tagging within each contract what clauses were to be considered unfair or potentially unfair, and also indicating the kind of clauses that we were classifying in this way. Our reference was the directive on unfair contract terms, and we refer to the directive, but also to the legal doctrine and case law available on the matter. We identified 8 kinds of clauses that were most likely to be unlawful or unfair. And we, as I said, identified the clauses in the document, classified them, and tagged them. Here are some examples of clauses that were considered unfair. Here you have some a couple of examples of clauses that are unfair because they established that the contract is agreed without an explicit consent by the consumer, but just by using the service in a context in which the consumer probably has no idea of what kind of agreement is entering into. You have one by Airbnb and one by Facebook. Other kinds of clauses that are unfair clauses that are very often included in contracts are clauses where the consumer agrees to give exclusive competence on deciding possible controversies to a court that is established not in the consumer's residence, but in another place, possibly outside of Europe, such in this case is the state, in this example from Dropbox, a well-known software for storing content in the cloud. The competence is given to the state courts of San Francisco, California. Other often clauses which are often unlawful or unfair are clauses on limitations of liability, where a company excludes the liability towards consumer for any kind of damages, including possibly even personal injuries or property damages. So finally, another kind of an unlawful or unfair clause are clauses concerning arbitration, where that is a mandatory arbitration established for consumer. This is also clearly against the law, which ensures that consumers can appeal to the judiciary of their residence. So we had to develop a system that would be able to identify what clauses are unfair and also to classify them according to the categories that we have just indicated. We tried various machine learning approaches, from statistical methods, taking into account single words and the combination of them, to the neural networks that are the most popular technology nowadays for this kind of exercises. We tried various experiments, and in the end, I think we got some good results. So our system is able to identify more than 80% of clauses of the kinds that I have indicated that are unlawful. So a very good record, I think, taking into account that such clauses are written usually in using very different languages, in very different contexts and positions. So I think that the outcome that we obtain is really useful. And on the basis of these good results, we built an online server. As you can see from this slide, it is freely accessible. You just have to type claudette.eui.eu and you get to this web page. You just passed a contract, an online contract or term of services into the window. And after a little time, 1 minute or less, you get an assessment of your contract that consists in the automated identification of the clauses that are unfair. Here you have an example where 3 clauses have been identified as unfair by violating the law or fairness in the domain of arbitration, unilateral change, and contract by using. You have to take into account that there is a huge amount of online contract today is available, and our research found that very many of them contain unlawful clauses. Consumers, as I said, never read them, and consumer organization and public authorities do not have the resources for checking every online contract. So I think that Claudette can be a very useful tool, both for individual consumers when deciding to sign an online contract, but maybe more than for them, for consumer organizations and data protection authorities that can analyze, examine, have a Claudette examine the online contracts, and then specialized legal experts can then go over the results provided by Claudette, having to examine a much smaller set of text, and be able to identify and further analyze the results automatically provided by the system and decide what to do on this basis. Recently, we have developed our system with a further feature, which we think is very important, which consists in the system being able not only to identify what clauses are unfair, but also to provide an explanation, to provide a rationale, telling the user why the clause that the system has classified as unfair has been subject to this judgment. So here you have an example, for example, where the second clause that concerns unilateral change, which is the supplier gives itself the right to change unilaterally the content of the contract, has been considered unfair since the provider has reserved from himself the right to unilaterally change the contract, the service, the good at his full discretion at any time. I think that this feature of Claudette can be useful for the consumers that can have an explanation of why a clause is not working well, but may also be for expert users which have a first idea of where the problem stands. We are still working to develop this approach in order to provide more elaborate, more meaningful explanation, and a technology I cannot dwell on that has been very advanced technology has been developed for this purpose, which is based on a complex kind of neural network. But this I can leave for another time for the questions. We have also developed an application of Claudette that concerns privacy policies using the same methodology that we have adopted with regard to terms of services. In privacy policy, the results so far are not as do not reach the level of the result that we have obtained with regard to the terms of services, but we are now developing the system, and the performance is improving. Finally, we have also developed a web crawler that checks whether there have been changes in the privacy policies that we have examined, and automatically signals every change, and then goes through the change to identify whether there are new unlawful clauses that have been introduced in the contract. So not only we examine terms of services at a snapshot, but we can also consider their evolution. And we are experimenting new methods, multilingualism. We are developing, the current version of Claudette is based on English, but we are also developing a version that is able to examine contracts in German and in other languages such as Polish or Italian. We are developing, as I said, the ability of the system to provide explanations. And finally, we are developing collaboration with consumer organizations. We have already done that with BEUC, but we are also contacting a national organization, because we think that our system can be most useful for consumer organization, in addition, obviously, to individual consumer. So thank you very much for your attention from the whole of the team of Claudette. Thanks a lot for giving us the opportunity to present our project to you.
Thank you very much, Giovanni. I think it's a very, very interesting project, one of the most promising projects I've seen recently, and which is really mixing law and computer science, as you mentioned. So now let's discuss about that and how AI in generally can help consumer protection. And let's start with Rossana Ducato. She's a lecturer at the University of Aberdeen, and she's also one of the few experts which master law and also computer science. You have worked a lot on legal design and how to help in a way to make the law more effective to a better design. So what do you think about this project and also the other project on which you have worked on? And what is the main message you could deliver to an institution like the Commission on how we can improve the consumer protection with AI?
So first of all, thanks, Alexandre. Well, with the organization of this seminar, you actually asked the famous $1 million question. So when you organized this seminar a few months ago already, you essentially asked, can AI help consumers? Well, you have seen already a very nice example. So you all attending the seminar, probably you have already a clearer idea now. So for the sake of the discussion, in the next 7 minutes, I will try to answer Alexander's question in 4 steps. So first of all, what are the current examples that are trying to improve consumer protection? So I will showcase some examples. The second point that I would like to raise is who can use these AI tools, so who can make the most out of them. The third point is what are the current legal obstacles to the path of AI tools development in this field? And the fourth final point is what are the technical limitations that we have to take into account in these sectors? So first of all, I'm going to show you some example of AI tools that have been developed so far. In my research, I'm just opening my screen sharing system. So you should see my screen now. So in my research at UC1, because before joining the University of Aberdeen, I was a proud researcher in Belgium. I focused in particular on machine learning tools that automatically analyze pre-contractual information and privacy notice of online platforms. And if I can make a sort of taxonomy, I have observed 4 main groups of tools. The first set of tools is based on information analysis and classification. So one of the first examples is usableprivacy.org, a project led at Carnegie Mellon, started in 2013. And policies. This has been developed at the EPFL in Lausanne with the University of Michigan. And these tools, as you can see, rely on visualization techniques to make the information more usable, so more salient and evident to the reader. A second group of tools, it's based on information annotation as well, but this kind of tools also express a judgment, so they go one step further. We have seen already the example of Claudette, so there is no need to say more words on this. And another interesting example is this one, GUARD. This has been based on the PhD thesis of a Spanish student in computing science. And this AI experiment is essentially giving a score of the privacy policies of a number of platforms. And it's an AI experiment that is not fed by a legal analysis in the strict sense. It's actually a crowdfunding experiment because everyone can take part to this experiment, and you can actually choose between 2 versions of some extracts of the privacy policies and vote for the most privacy-friendly option. A third group of AI tools developed in this that could support consumer protection are comparison tools. This one, for example, is PolyCompare. That's been created by, again, the EPFL in Lausanne with the University of Michigan. So relying on the policy annotation, such tools contrast and compare 2 or more privacy policy in this case. And there could be also an evaluation of them. So you can see that there are some warning, for example, about some tricky passages of the privacy policy taken into account. Finally, a fourth and final group is the universe of legal chatbot. Again, this has been developed by the Swiss and Michigan team. This is Prybot. And another one at the university. So here I'm presenting some examples that respond to users' query on the basis of the information contained in the contract of the privacy policy. But this really is an area that is growing a lot, and it can also raise several issues from a legal point of view in terms of liability, deontology, if legal chatbots are going to give legal advices to individuals directly. So these were just some examples. I can stop the sharing on my screen so you can see me again. Second point, who can use such tools? Who can make the most out of them? As Giovanni was saying already, consumers, because these kind of tools can be used for raising the awareness of consumers, making the information more evident, more salient. Consumers can be more aware of the rights, obligations, the possible risks, and so on. So in principle, if they have the information available in a more transparent way, they can do better decisions. Then, of course, consumer association and enforcement authorities can use these tools to monitor market, detect possible infringements and threats in a more efficient way. Giovanni was again stressing the issue that we have to cope with limited resources. And finally, also companies, because if such tools are going to be used on a large scale, companies might decide to compete for offering better terms and conditions to consumers in order to get a higher score on these kind of AI tool results. Now, there are several obstacles that we have to face when we are going to develop this kind of solutions. First of all, there are legal obstacles. So I'm coming to the third point. All the tools that I presented here are essentially based on text and data mining. What is text and data mining? Text and data mining uses techniques from natural language processing, machine learning, knowledge management for the automated analysis of digital content in order to extract information, patterns, detect correlation, and so on. Now, the problem is that in most of the cases, in order to work, text and data mining has to make a reproduction or an extraction of the content of the website. In other terms, these tools have to make a copy of the content of the website. Now, under copyright law, under database protection law, if you want to make a copy, either you have the authorization of the right holder, which is very difficult if you have to analyze thousands of documents, either you rely on a copyright exception. Now, the new directive on copyright in the digital single market is actually adding 2 new exceptions for text and data mining. The problem is that they are very narrow, so they might not be applicable in this case. This point will require more explanation, but I will leave this for the question later. I just would like to say that with Alan Strowell, we have worked on this and we have tried to propose a solution to overcome this problem. Final point. There are some intrinsic legal technical issues linked to algorithmic decision-making in general and in particular for this specific context. All AI tools, including those that we have seen so far, have to be taken with a pinch of salt. I strongly believe that AI tools can flag issues and can automatize certain tasks, but cannot perform all possible legal assessments. So in my opinion, it's always crucial to keep the legal expert in the loop during the development of the solution and also after, when it's the moment to judge the result of the evaluation. As we know from the time of Roman law, essentially the ability of use dictionary is always a case-by-case evaluation. So it's always difficult to evaluate all the elements of the context. And also we have seen in other fields of technology, I'm thinking in particular to recognition technology, like for upload filters and so on, that such technology is not always accurate as it cannot always recognize the context. So it might happen that also the interpretation of contractual document might be misled because the AI tool does not have the full overview of the transaction. So technology can flag the issue, but then the decision should be always supervised by a legal expert. So that's why when such technologies are offered directly to consumers, I think that we have to be very, very careful and clear about what they can do and what they cannot, because such tools cannot be misleading and add problems on top on another problem. And so it's always important not to create false expectation when these tools are given to consumers directly. Furthermore, consumers might not have the time, the skills, the technology for using such tools. So when we are, who is going to have access to the technology is always a question that we have to ask ourselves, and we have to be mindful of not creating a new form of exclusions. In any case, AI tools are tools. So they are not a magic solution to solve the lack of transparency in the platform economy. They can support, indeed, the consumer protection, but they have to be considered as a part of a larger strategy and framework, indeed, for consumer and data protection. So, Alexandra, can AI help consumer protection? Yes, but at some conditions.
Thank you very much. And as I understand, one of the conditions is that they will never replace lawyers, which for us lawyers, it's a good perspective. No, but you mentioned very important point, and one is it's true that law is very often based on open clause, and it's very rarely black and white, you know, while a computer tends to be black and white. And you know, when we all collaborate with computer scientists, and in fact they are better lawyers than lawyers, because you know they are so logical, but sometimes they miss this flexibility that you can find in law. That's one problem. The other problem, and I think it's very important, is that you know AI will never replace the human. I mean, and I think all the challenge of a good AI strategy here are elsewhere is to try to take the best of each of intelligence, the artificial one, if we can call it intelligence, which I think is always a bit strange, but okay, let's do it, and the human intelligence, and to be a bit like David Ricardo, saying that, trying to ask everyone to do its best thing and to have a kind of specialization and then to combine. Thank you very much. Ursula from BEUC, so you are the voice of the consumer in Europe, and so I guess this kind of project should interest you a lot. I mean, Giovanni already mentioned that there is a cooperation between BEUC and you. So the question is how the consumer organization see those kind of tools as helping your own work and your own objective. Thank you very much also for joining us.
Thank you very much, Alexandre. Thank you very much, Sarah. And thank you very much, Giovanni, also for the introduction on Claudette. It's great to see how Claudette evolves and how it grows, and adding explainability and language features is certainly very, very valuable. A very quick introduction to just comment on something that Commissioner Reynders raised a lot, and which is generally a lot referred to in the discussions on AI. It's consumer trust. Consumer trust. Obviously, that is also very important for our discussion, because if AI should protect consumers, consumers need to also use it, and they need to have to trust in the technology. And currently, and that's the point I wanted to make, we have just recently done a multi-country survey about consumer trust. The results are not good. Consumers have a lot of expectations. They think AI could be very useful in certain areas, but they have a lot of concerns. Just to give you a few numbers, 60% think that there will be more abuse of personal data. 64% think that there will be potentially more manipulation of consumer decisions. 55% are worried about their privacy when it comes to AI. So there is a lot to do. And I just show you this. This is the survey that you can find on our website, and the results and the recommendations that we give. But let me come back to now, I would like to focus around 2 points. First of all, what AI tools can be useful for consumers, but also for consumer organizations or for authorities that are tasked with consumer protection, enforcement, and oversight. And the second point, a bit like also Rossana did, is looking at what are currently the limitations of AI, what are the obstacles, what needs to be done. I don't need to say a lot about the first point, because I think we have seen already a lot of descriptions of the different functionalities. Maybe just to underline, authorities and consumer organizations have something in common when it comes to the market and the watchdog function that they have. Our members do a lot of testing, they do a lot of monitoring, they do a lot of reporting about how markets develop, particularly now in the digital markets. That is extremely important due to the increasing complexity. And so we see a lot of potential in helping consumer organizations with complaints compilation, with analysis of complaints, and with discovering by that easier analysis systemic problems that we have in markets. We have not so much talked about the safety of products, but that's obviously also an important area where technology like AI, blockchain, for example, can help to identify dangerous products that appear on the market and then disappear, but maybe come back in a very similar disguise, so to speak, and then need to be traced. So traceability and product safety, product quality, that is very important, can be useful for consumer organizations and for authorities. And then we will also have to use probably AI to test AI applications or to test, for example, connected products that use AI. And I'll come back to that later. Then, of course, the side of the consumer empowerment. I think Rossana gave a lot of examples. Claudette is, of course, a very important example, but maybe also just to say, I mean, we also need to look at the market as such. If Facebook, for example, uses unfair clauses, like Giovanni showed an example, what can I do with that information? Because all my friends are on Facebook. I cannot really switch to somebody else because we don't have interoperability between platforms and social media. So there are some systemic problems that also show the limits of a consumer empowerment through AI. And then we have seen the advice functions and the chatbot function, and Rossana explained that. Another aspect that didn't come up so far, which I think can be interesting, is dispute resolution. We see already private actors offering mediation services online, I don't know how good these services are. We haven't been able, our members haven't tested that yet, but just to say this is appearing already. What I find particularly important is to look to the future with regards to mass claim resolution of disputes and court activities. We have now, and we will very soon have, the Representative Action Directive, which will come with collective redress finally also for Europe. So that's important. And there we can have a lot of important help, like compiling the complaints, categorization of complaints, so that the cluster of the mass claim can be defined with much less administrative effort. And then the second point, as I said, I would like to very briefly switch to the obstacles and limitations of AI. And here I would like, first of all, to touch upon the fact, of course, there is already, we see it a little bit asymmetry in what private players have in terms of resources and what, for example, consumer organizations have in terms of resources to develop AI tools. Consumer organizations do a lot of product testing. How are they going to do that when they have products that use AI? Are they going to have access? Is there documentation available? Is there publication of the main features of the algorithm, of the software, etc.? So that's a big question. And for all of that, the point I want to make is we need much more public funding of these type of support for public interest activities. I mean, authorities and enforcement, they will need help. Authorities will not be able to have all the expertise and all the tools. Consumer organizations will also need support to develop these tools to continue their work as market watchdogs. The second point is access to data. That is certainly something very important. So how do we ensure that there is open sourcing so that we can really develop the respective tools and to apply them? What type of documentation will businesses who use AI have to provide? And there, the regulatory framework that we will see at the beginning of next year, as Commissioner Reynders explained, will be absolutely decisive in seeing how this access can be enabled or not. And the third point I wanted to make again is what do consumers really want? And here we know they have not a lot of trust yet, but we also know that they, when it comes, for example, to complaints resolution, they still prefer to talk to humans. When it comes to the question, would you be okay to have an automated machine process to decide on your complaint or to advise you? We know from surveys that most consumers say, I prefer to speak to a human, I prefer a phone call. And so what expectations do consumers have? What are they ready to accept in terms of engaging with AI tools? And what can be done about that? So again, I'm coming back trust is very important, but trust is something we should focus on, but not instead of looking at what legal framework we need, but in addition to how can the legal framework enable trust and how can we enforce the rules that will be decisive. I stop here. Thank you very much.
Thank you very, very much. And thank you very much also for pointing the opportunities of those tools, but also the importance that, I mean, you and consumer organization and regulator are able to catch up. And as you say, I mean, there is a lot of asymmetry of information, of competence at this stage. And clearly, I think one of the role of the state in general is to try to decrease this asymmetry of information and skills that you mentioned. So let's go now to the state. So to Marie-Paule Benassi, thank you very much. You are the head of unit of consumer enforcement. And so I wanted to first ask you, do you have AI people in your team or not, or do you plan to have some of them? So that's the first very precise question. And then more generally, how do you see those AI tools as helping your own mission in enforcing or helping the enforcement of consumer protection? Thank you very much also for being with us.
Thank you, Alexandre, and good afternoon to all of you. And I smile with your question because I'm a statistician by training, an econometrician, and I worked in the French statistical office long ago in '85. And at that moment, I was part of a team developing a tool to do automatic commenting of international indicators and language, so automatic language and analysis. And as you all know, who have been in this discipline for a long time, there was a sort of high expectation at that time, '85. And then the progress were too slow, and we said, and I remember very well in my office, we said, no, but at the end, it's faster when we do it ourselves. So I think I am the early AI specialist of my team, and I've been pushing a lot in the last years for us to do a lot of new research and projects in using AI. And we plan to develop systems, to procure systems, and to hire specialists. So what are our plans at the moment? So we have, I think, and I will concur with what Ursula said. There are many different types of uses of AI and also challenges. So what we are currently working on is 3 areas. The first one is supporting consumer authorities and the enforcement of consumer legislation and product safety legislation. The second one is market research. And the third one is assisting consumers. So in the first domain, we have already done a number of things. So we have already procured a study on existing AI tools for enforcement of consumer rights. And one of the tools, for example, which was evaluated by the University of Maastricht, which was our consultant, is Claudette. And we had the opportunity also to demonstrate Claudette to national consumer authorities. We have a group of a network of national consumer protection authorities, which are running under the Consumer Protection Cooperation Regulation, CPC. And we have a subgroup, which is called the e-enforcement group. So it's a group which is really specializing in online investigations, and they are doing exchange of best practices, but we have also developed a training program, which, for example, we learn and we help them develop their knowledge of web crawlers or other systems, for example, to assess reviews, whether reviews are genuine or not, so using text mining techniques. And we want to move now to the next phase, which we call the e-lab. So the e-lab, and we have already announced it, for example, as part of the Commission plan on the enforcement of the single market. Single Market Enforcement Action Plan. I think this is the name of the communication. So this e-lab, it's an idea of developing a platform by the European, and which would allow national consumer protection authorities to share the same tool and a hosting solution. I see my internet connection is unstable, so I hope that you hear me well. So sorry for that. So the idea is really to build on the fact that these tools can be used in a cloud configuration, and so we could give access to all authorities from all the member states. And as you know, some authorities are better equipped than others. We are also working on a web crawler system for product safety, for example. And one of the things which we see is that when you take down a product, this same product reappears with slightly different names, or a different name of a different trader, and so on. So also a system which could help address online safety issues. Market research is another big area on which we are working. But market research is in terms of enforcement. It's to find problems on markets. So, for example, a system like Claudette is very interesting for enforcers to find traders which show unfair terms. And as Rossana said, it's then needs to be further investigated by the lawyers of the enforcement authorities. But we have now we are working on a prototype for a system that we call the complaints watch. So the idea is to use complaints data, so real complaints data, which are collected across the member states by various complaints handling bodies, and to use big data techniques, text mining, to do ex post classification of these complaints, because we tried 10 years ago ex ante classification of complaints data, and unfortunately didn't work. It's super heavy to obtain something like that, and so we think that by this system we can really have a real-time observatory of the complaints of the consumers, and this would help national authorities to identify emerging trends in terms of what's not going well on the markets. And finally, a big area on which we are only starting to invest is tools for consumers. I think tools to help consumers, because we are investing on AI in products and in markets. As you know, the Commission has announced already that it has a strategy on AI, on ethical issues, safety issues, and we go a step further because we are preparing the revision of the General Product Safety Directive, where we will take into account, of course, all the challenges posed by the fact that there are AI systems embedded in the products or in the software which goes together with the products. But in terms of direct help to consumers, we are looking into the ODR platform. So it's a platform where consumers come in millions, in fact, to better understand what are their redress possibilities. And we see that many consumers arrive on the platform and leave immediately the platform because they don't find on the platform what they need. And what they need is a few advice on what is their problem. And this using natural language processing, so that to help them understand what is their problem, whether it is likely that their rights have been infringed, and a number of scenarios that they could try. Each of these scenarios would lead to a dispute resolution solution. The first one is go to the trader. Go to the trader and tell the trader that this and these rights have been infringed. Because we see that when the consumer has a better understanding of what is his right or her right, then the traders listen better. The second thing is, of course, advising them whether they should contact a European Consumer Center or a consumer organization or a national authority. And then the last one will be maybe at the end of the day, because you have already tried a number of things, you can launch an alternative dispute resolution. And then leave, of course, then the alternative dispute resolution to the professional alternative dispute resolution bodies that we have in the Union. So these are the areas on which we are working. We are going to publish very soon. The Commission is going to adopt the consumer agenda, the new consumer agenda. So a part of these questions are going to be described in this document. And I wanted to finish by saying that an area on which we have not yet invested, but we will in the future, is vulnerable consumers. Because vulnerable consumers, traditionally we have the minors and the elderly people, but you can have other types of vulnerability, and of course, people in financial difficulties, for example. So vulnerable consumers can both be victim of, let's say, not well-conceived AI system, of manipulative AI systems, but they can also be helped by AI system. And so how such system, because it's going to be, most of these systems are going to be services. So the services needs to be reliable and well-conceived and really producing the expected benefits in a fair manner. Like, for example, personal assistance. So thanks a lot, and thank you for starting this very, very interesting and important topic of discussion.
Thank you very much, Marie-Paule. I know that we were in a good hands when I asked you that question, and it's very, in a way, reassuring that to understand that really the Commission is also looking at the opportunities of AI in enforcing the rule, because we know that one of the big problems of EU law very often is enforcement. You know, we have good law, but then they are poorly enforced. I mean, all the last exercise of reforming consumer protection was about enforcement, but I must say I found that there was very little on AI. Maybe it was a bit too early, but I think you reassure us with all this program of action that you have, and we will read the consumer agenda with a lot of pleasure. So unfortunately, we have to conclude here. There was some question on Slido, but they have been replied directly to the question, and thank you, Giovanni, for that. I would like really to thank the speaker. I think it was a very interesting debate, and you know, it was a positive debate on AI, because I think too often, sometimes in Brussels, you know, we have this debate which is saying, okay, there is this risk there and over there, and we should intervene and we should regulate, and I mean, there is a lot of opportunity, and this is really the tone that we wanted to have at SER. Of course, without denying that there are some risk, but there is as many opportunities as risk. And I also like very much what Rossana was saying that, I mean, it's a combination of both, you know, of lawyers, humans, and machine that will improve our environment. I would like to thank the SER team again for having organized that event, and I guess that the video with Commissioner Reynders was time-consuming to do, so thank you very much for that. And stay tuned on the future SER event. We will continue to work on those issues, and I'm sure Marie-Paule and others, we will re-invite you at some point, because I think it's very, very important that think tank like us and others follows that and feed the decision maker with new ideas. Thank you very much to all, and good afternoon, everyone.
Thank you very much. Bye-bye.
Thank you. Bye.